Hello and welcome to the fourth video lecture in your program on Advanced Patent Law.
In this unit, we will learn about different types of application that can be filed before the Patent Office. The different components that we will look at are different types of applications in which we will discuss 1. Provisional application, 2. Complete application, 3. Cognate application, 4. Convention application, 5. Divisional application, 6. Patent of addition, and 7. International and national phase applications. Please note that the types of applications discussed in this unit are allowed before the Indian Patent Office. Other countries may or may not facilitate all such types. Before getting into the details of each type of application, it is important to note that an application is to be filed before a patent office under which the jurisdiction lies. This is so because there are 4 patent offices in India, namely Delhi, Mumbai, Calcutta and Chennai.
Please note, the details of the address of the different patent offices in India have been provided in the supplementary material to this unit.
Coming back to the types of applications, let's understand what each type is and when can it be filed. First, we deal with provisional applications. This application is a great benefit for the inventors. But what's the reason?
We have discussed in the previous units that India follows first to file system, which means whoever files the patent first gets the patent.
Consider this: an inventor has a new concept and intends to develop it further. After spending a couple of hours working on it, he still believes he needs more time. What should he do? In such cases, the Patents Act provides filing a provisional application that acts as a placeholder and sets the priority date. This means if someone else were to file an application for the same or similar invention after this date, even then the first inventor's application will stand while others will not be considered. The caveat is that the inventor, after filing the provisional application, has to file a complete application within 1 year of the provisional filing date. Effectively, this means that the inventor earns 12 months more before he can file a complete patent specification, and he can use the same time to develop the invention further. The provisional application should contain the title, background, and the summary of the invention.
Let's understand this by way of an illustration.
Professor Xavier files a provisional application on 20th July 2011. Professor Xavier has time till 20th July 2012 to develop her invention and file a complete application for the same. Extension beyond July 20, 2012 is not possible. However, there is a provision in the Patents Act to postdate a provisional application. The maximum period for which an application can be postdated is 6 months. In such case, the priority date will also shift by the same number of months. That is, in the above example, if the provisional application is postdated by 2 months, the priority date would be 20th September 2011. Next, we deal with complete applications. A complete application is also called a non-provisional or regular patent application. This application may be the first filing that an applicant makes for his or her invention or a subsequent filing. It can be a subsequent filing if it is filed claiming priority from an earlier filed provisional application. Please note that a complete application contains all the parts of a patent specification as discussed in the previous unit. We now move on to cognate application. Consider Professor Singh has invented a plane with wings, for which a provisional application is filed on January 3, 2011. While working on the invention, Professor Singh found that arched wings were preferable, and therefore he filed a second patent application on August 8, 2011. In such situations as above, it is possible to club the two provisional applications and file a single complete application, as the two inventions have a single inventive concept. The thing to keep in mind is that while filing a cognate application, the application has to be filed within 1 year of the earliest priority date. In this case, the complete application has to be filed by January 3, 2012. But the priority date of the subject matter of the cognate application will correspond to the respective provisional filing date. That means, in the above example, in the complete filing, the subject matter that corresponds to the first provisional application will have the priority date of the first provisional filing, that is January 3, 2011, while the subject matter that corresponds to the second provisional application will have the priority date of the second provisional filing, which is August 8, 2011. Please note that a cognate application can be filed for two or more provisional applications and not complete application. We will now discuss convention applications. This is an application that claims priority from an application filed in a member state of Paris Convention or a country with which India has an arrangement like bilateral ties, etc. This application can be filed within 12 months of first filing. No extension is permissible. In case one or more convention applications are filed for two or more inventions in convention countries which are cognate or of which one is a modification of the other, in such case a single convention application may be filed at any time within 12 months from the earliest priority date. In this case too, the priority date of the subject matter would correspond to the respective priority date of earlier filings. Please note that the term of the application will be 20 years from the date of application in India and not from the earliest priority date. Next, we deal with divisional applications. A divisional application is filed as a result of a complete application containing multiple inventions.
As per the Patents Act, only one invention can be filed in a patent application. But there are times when two or more inventions are filed in one application, which is eventually refused by the Patent Office for not conforming to the Act.
Then, rather than abandoning the application, an applicant can file one or more divisional applications such that each application contains one invention. Let's understand this concept by way of an illustration. Consider this: there are three applications A, B and C which contain inventions X, Y and Z. Application A corresponds to invention X, application B corresponds to invention Y, application C corresponds to invention Z. Applications B and C will be referred to as divisional applications and will have a filing date of the main application, namely application A. Alternately, an applicant can himself or herself divide out the application in case the applicant feels that the application has multiple inventions. Though there are pros and cons to filing a divisional application, let's consider these. The pros of a divisional application are: it prohibits an application from being rejected, the rejection of multiple inventions. If an applicant has financial constraints initially, he may file a single application for related inventions and can later divide out the application into one or more divisional applications. The cons are, it delays the grant of a patent.
Next is the patent of addition, which is basically the inverse of provisional application. Let us understand this concept.
We studied that a provisional application can be filed before a complete application, but a patent of addition can be filed after the filing of a complete patent application. That is, while a complete application can claim priority from a provisional application, a patent of addition can claim priority from a complete patent application. Typically, a patent of addition can be filed when there is an invention that alone would be obvious in light of the previous filing by the same applicant and therefore will not be awarded a patent. Therefore, by filing a patent of addition, the applicant can seek a patent and not receive objections due to the main filing. Well, let's take an example to further understand what is this kind of an application. Let's say Professor Xavier files a complete patent application CA1. He then files a patent of addition PA1 claiming priority from CA1. In this case, CA1 will not be considered for novelty or obviousness rejection of PA1. The term of the patent of addition, though, will start from the date of filing of the main application.
Next is the international application and a national phase application. International application is the application filed under the PCT.
A PCT application has two phases. First, an international phase, and second, a national phase. Let's study this with the help of the following graph. In the international phase, either a PCT application can be filed as the first filing, as shown in the graph, or within 12 months of national or regional patent application filing. As shown in the graph, a national filing can be a filing of a complete or provisional patent application.
Please note, a regional filing applies to the European Union or the African regional patent application.
It should be noted that if a PCT filing is the first filing for an invention invented in India, then either a permission for foreign filing should be sought from the Indian Patent Office or permission should be filed along with the PCT application. The PCT application can be filed with any receiving office in India or with the International Bureau of WIPO. Thereafter, a search report, namely ISR, is issued for the international application along with a written opinion in the 16th month as shown in the graph. The applicant has an option to file for any amendments within 2 months of the ISR as shown in the graph. Subsequently, the application is published at the end of 18 months. We will study the prosecution stages in detail in the next unit. An optional stage, that is, request for supplementary examination, is possible in the 19th month of the international phase.
The application is further examined and the result is communicated to the applicant. Similar to the previous instance, the applicant can file amendments.
The amendments can be filed centrally before the International Bureau. Further, the applicant has another advantage, which is the applicant can assess the chances of grant of the application and accordingly proceed before entering the national phases of the corresponding application in the respective national patent offices.
This is a huge cost saving exercise. After this, the application can be filed in different countries. This phase is referred to as the national phase application.
In India, a national phase application is filed within 31 months of the first filing. In case a request for supplementary examination is not to be filed, the applicant can make national phase filings earlier. From the above, you can infer that PCT can be a great tool for filing a patent application if the applicant desires to file such application in several countries. The applicant gets time to make national phase filings and can stagger the costs. Also, because the first stage search is conducted, the applicant may find it helpful to have a preliminary assessment of the invention, based on which the applicant may either decide to pursue filing in national phase countries or may altogether abandon any further course of action on the patent application. With this, we come to the end of our discussion on types of patent applications. In the next unit, we will learn about various stages which are involved in a patent process right from filing to grant. Thanks for watching.